April 2nd, 1993. A courtroom in Jamestown, California. A mother stands, draws a pistol from her purse, and fires 5 shots into the head of the man accused of molesting her son. The court called it manslaughter. The town called her a hero. What follows is the story of 15 parents who decided the courtroom wasn't fast enough, and what it cost them. Case 1. Ellie Nessler. Jamestown, California, sits in the Sierra Nevada foothills, a small town built on old gold mining ground. The kind of place where courthouses are small and everyone tends to know everyone else's business. In the early 1990s, it was the kind of community where a summer camp run by a church group felt like the safest place a parent could send a child. That sense of safety is where this case begins, and it is also where it ends. Ellie Nessler was a single mother raising her son William, who went by Willie, in Tuolumne County. Life had not been easy for her. She had grown up with her own history of abuse, and by her mid-30s, she was working hard to keep her family stable. In 1988, Willie, then 6 years old, attended a camp connected to a Christian ministry. The camp employed a man named Daniel Mark Driver, who worked with the boys there. Driver had a previous conviction for child molestation, a fact that was not widely known to the parents who trusted him with their sons. According to court records, Driver sexually assaulted several boys at the camp, including Willie. Driver reportedly told the boys that if they spoke about what happened, he would hurt them and their families. For months, Willie carried that secret. When he eventually told his mother, the truth came out in fragments, the way disclosures from children often do. Ellie Nessler was horrified. She brought the accusation forward, and in May of 1989, a criminal complaint was filed against Driver, naming several victims. But Driver had already fled the area. For nearly 4 years, he stayed ahead of the law, moving from place to place, avoiding arrest. During that time, Willie struggled. Court testimony later described him as hypervigilant, afraid that Driver would return and make good on his threats. He began asking his mother questions about death and suicide. At one point, Nessler found her son in possession of a gun. The family lived under the shadow of an unresolved case, a missing defendant, and a child who could not move past what had happened to him. Driver was finally located and arrested in late 1992 or early 1993. A preliminary hearing was scheduled in Tuolumne County to determine whether there was enough evidence to send the case to trial. For Ellie Nessler, this was supposed to be the moment when the legal system finally caught up to what had already happened to her son. Instead, it became the moment everything changed. On the morning of April 2nd, 1993, Nessler arrived at the Jamestown Justice Court for the hearing. Also present that day was a courthouse investigator, and at one point, before the hearing began, Nessler asked him a question. She wanted to know whether he or others in the district attorney's office would get in trouble if something happened to Driver. The investigator, believing she meant a previous jailhouse assault on Driver by another inmate, told her no one would be blamed for that. It was a moment that would later be examined closely by both prosecutors and Nessler's own defense team, each side reading different meaning into it. When the hearing was called, Driver was brought into the courtroom, shackled and seated near his defense attorney. The judge had not yet entered. The courtroom was relatively empty. Nessler stood behind the defense table. She had a handgun that, according to court records, she had taken from the purse of a family friend seated near her. She drew the weapon and fired 5 shots into Driver's head and neck at close range, with the muzzle only 2 or 3 feet away. A 6th shot missed and struck the wall. Driver died almost instantly. Nessler lowered the gun and made no attempt to run. She was arrested at the scene. News of the shooting spread quickly through Jamestown and then across the country. Reporters and television crews arrived within hours. Local residents largely rallied around Nessler. A cafe owner near the courthouse told a reporter that Driver had deserved what he got, calling child molestation the worst crime there is. A collection was started for Nessler's legal defense. At the same time, the district attorney's office called the killing reprehensible, and Nessler was released on $500,000 bond while she awaited trial. The case that followed was legally complicated. Nessler was charged with murder, but as the evidence unfolded, her legal team built a defense centered on her mental state, arguing that years of hearing her son's fear, watching him deteriorate, and living through the frustration of a justice system that had let Driver evade arrest for years had pushed her into a break from ordinary judgment. During the guilt phase, the facts of Driver's abuse of Willie and the other boys were laid out in detail. During the sanity phase, 3 defense experts testified that Nessler was legally insane at the time of the shooting. 2 of them attributed this to post-traumatic stress, rooted in her own history of abuse, as well as what Driver had done to her son. They argued that on the day of the hearing, sensory and emotional cues, including her exchange with the investigator and the sparse courtroom, led her to believe that what she was about to do was somehow sanctioned or expected. The jury did not accept the insanity defense in full, but it did find Nessler guilty of voluntary manslaughter rather than murder, along with a firearm enhancement. It was later revealed that jury misconduct had occurred during the sanity phase of the trial, and this became the basis for an appeal. The California Supreme Court ultimately took up the case, ruling that the misconduct had likely prejudiced the outcome of that portion of the trial. Rather than proceed through another lengthy legal battle, and given that Nessler had been diagnosed with breast cancer while incarcerated, she reached an agreement with prosecutors. She pleaded guilty to manslaughter in exchange for a sentence that allowed her release after roughly 3.5 years behind bars. Nessler was released from custody in 1997. Her case had already become a national talking point about vigilante justice, sparking debate in newspapers and on television about whether a parent's rage in response to child abuse could ever be excused by the law, and about the limits of a legal system that had allowed a known predator to evade arrest for years while a child suffered in the aftermath. The years after her release were not gentle to the Nessler family. In 2002, Ellie Nessler was convicted on charges related to selling and possessing methamphetamine and served additional time. Her son Willie, whom she had gone to such lengths to protect, was later convicted of first-degree murder in 2005, after killing a man he believed was taking advantage of the family in a property dispute. He received a sentence of 25 years to life. Ellie Nessler was diagnosed with cancer again and died in December 2008 at the age of 56, with her son unable to attend her funeral because he remained in prison. Looking back, the case remains one of the most cited examples in American legal history of a parent responding to child abuse with lethal violence inside the very institution meant to deliver justice. It raised questions that were never fully resolved. Was Nessler a mother pushed past the point of endurance by watching the system fail her child for years? Or was she a woman who made a choice that ended a life in a room built for reasoned judgment rather than vengeance? Both her supporters and her critics agreed on one thing. The case exposed how deeply a parent's protective instinct can collide with the slow, uncertain machinery of the law, and how, when that collision happens in public, in a courtroom crowded with witnesses, the aftershocks can travel through an entire family for decades. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. A courtroom in California quiets after 5 gunshots, and a mother's grief becomes a national argument about justice. Next, the story moves to Lübeck, Germany, where another mother would sit through a killer's trial with a gun hidden in her purse. Case 2, Marianne Bachmeier Lübeck, is an old port city in northern Germany. Its center built on a small island surrounded by the Trave River, a place known for brick Gothic architecture and a history stretching back to the medieval trading league that once controlled commerce across the Baltic. In the late 1970s, in a quieter corner of that city, a woman named Marianne Bachmeier ran a small pub called Tipasa. She raised her young daughter there, often keeping her close during the working hours of the bar, a life that was unconventional by the standards of the town, but not unusual for a single mother trying to make ends meet. Bachmeier's own childhood had been difficult. She was born in 1950 in Sarstedt, a small town near Hildesheim, into a strict and religious household. Her father had served in the Waffen-SS during the war, and her upbringing was shaped by rigid expectations that she later moved away from as an adult. By the time she was in her 20s, Bachmeier had already given birth to 2 children from earlier relationships, both of whom she placed for adoption. Her third child, a daughter named Anna, was born in November 1972, and this time, Bachmeier chose to raise the child herself. Anna grew up around her mother's pub, described by people who knew her as a happy and open child, comfortable moving between the adults in her mother's orbit. She sometimes slept in the bar while her mother worked into the night. Friends later said Bachmeier expected Anna to take care of herself in ways that were unusual for a girl her age, treating her, in some ways, like a small adult rather than a child who needed close supervision. This was, and remains, a detail that shaped how the public would later view Bachmeier, though it does not change what happened to Anna. On the morning of May 5, 1980, Anna, then 7 years old, had an argument with her mother and decided to skip school. Rather than going to class, she made her way to the home of a neighbor she had visited before, a 35-year-old butcher named Klaus Grabowski. Anna had gone there in the past to play with his cats, an ordinary kind of neighborhood familiarity that made the house feel safe to a child who had no way of knowing what Grabowski had done in his past. Grabowski was a convicted sex offender. He had previously been sentenced for sexually abusing 2 young girls, and in 1976, he had voluntarily undergone chemical castration as a condition connected to his earlier offenses, a practice that was used at the time in West Germany in an effort to reduce the likelihood of reoffending. What was not widely known at the time was that Grabowski had also undergone hormone treatment afterward, in what investigators later determined was an attempt to reverse the effects of the castration. According to prosecutors, Grabowski held Anna in his home for several hours that day. He sexually assaulted her and then strangled her using a pair of his fiancée's tights. He packed her small body into a box and left it on the bank of a nearby canal. It was Grabowski's own fiancée who eventually went to the police, prompting his arrest. Once in custody, Grabowski confessed to killing Anna but denied that he had sexually assaulted her. Instead, he offered investigators a strange account, claiming that the 7-year-old girl had tried to extort money from him, threatening to tell her mother that he had molested her unless he paid her. He said his fear of returning to prison drove him to kill her. For Marianne Bachmeier, the loss of her daughter was compounded by the horror of Grabowski's explanation, an account that placed blame on a child for her own murder. As the case moved toward trial roughly a year later, Bachmeier's grief did not fade. According to a friend who spoke in a documentary years afterward, Bachmeier practiced with a gun in the cellar beneath her pub in the months leading up to the trial, though this claim surfaced long after the events and was not something established at the time. Grabowski's trial opened at the Lübeck District Court in March 1981. His defense argued that his actions were connected to a hormonal imbalance brought on by the treatment he had received after his castration, an argument that struck many observers, including Bachmeier, as an attempt to excuse what he had done to her daughter. By the 3rd day of proceedings, Bachmeier had reached her limit. She had smuggled a .22 caliber Beretta pistol into the courtroom inside her purse. During a pause in the session, she rose, drew the weapon, and fired at Grabowski's back. She fired 7 or 8 shots in total, 6 of which struck him. He died on the courtroom floor within moments. Bachmeier lowered the gun afterward and did not resist when she was taken into custody. According to a judge present that day, she said only that she had wanted to kill him. Witnesses also reported her saying that he had killed her daughter and that she had meant to shoot him in the face but had hit his back instead. The shooting immediately became a sensation across West Germany and internationally. Reporters and television crews from multiple countries traveled to Lübeck to cover the story. Outside the courthouse, crowds gathered chanting that they understood what she had done. Bachmeier reportedly received as many as 15,000 letters of support while she awaited her own trial. The German magazine Stern paid her roughly 100,000 Deutsche Marks for the rights to her story, money she used to help fund her legal defense. Bachmeier's own trial for Grabowski's killing became one of the most closely watched court cases in West German history. She testified that she had experienced something like a dream state during the shooting, describing visions of her daughter in the moments before she fired. Prosecutors, however, argued that her actions had been planned. The case turned in part on the question of premeditation, since a finding of premeditated intent would carry a harsher sentence than one of manslaughter committed in a state of overwhelming emotion. During the 28 days of court proceedings, public opinion around Bachmeier began to shift. Early sympathy had cast her as a grieving mother pushed beyond endurance. But as Stern's coverage revealed more about her life, including the fact that she had placed 2 earlier children up for adoption and had raised Anna in an unconventional environment centered around her bar, some of that sympathy eroded. She no longer fit neatly into the image of the blameless, devoted mother that had first captured public attention. Even so, many people continued to voice support for what she had done, seeing it as an understandable, if illegal, response to an unbearable situation. In March 1983, the court convicted Bachmeier of premeditated manslaughter and illegal possession of a firearm. She was sentenced to 6 years in prison. A survey conducted around the time of her sentencing found German public opinion split on whether the punishment was fair, with roughly equal portions of respondents believing it was too harsh, too lenient, or about right. Bachmeier ultimately served about half of her sentence, being released in 1985 after serving 3 years. After her release, Bachmeier's life took her far from Lübeck. She moved to Nigeria, where she married and lived for a period of years. Later, following a divorce, she relocated to Sicily. She eventually returned to Germany after being diagnosed with pancreatic cancer, choosing to spend her final months in the country where her daughter was buried. Marianne Bachmeier died in September 1996 at the age of 46. She was buried beside Anna at Bergtor Cemetery in Lübeck, the mother and daughter reunited in the same plot of ground more than 16 years after Anna's death. In the decades since, the case has remained a fixture of German cultural memory, referenced in documentaries, stage plays, and films that continue to revisit the question at its center. Was Bachmeier a mother who had simply run out of ways to bear her grief, or had she made a calculated decision to take a life in a room built for the deliberate, careful weighing of justice? German news outlets have described her act as one of the most significant instances of vigilante justice in the country's post-war history, a case that forced a nation to reckon with what happens when the pain of a parent collides directly with the formal process meant to resolve it. Bachmeier herself never expressed remorse for what she did, and in her final months, she chose to have a documentary crew accompany her, ensuring that her side of a story that had never fully settled in the public mind would be recorded one last time. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. A courtroom in Lübeck falls silent as a mother's decades-old grief finally speaks for itself. Next, the story moves to rural Arkansas, where a father would search the dark for his missing daughter and find her in a stranger's truck. Case 3. Aaron Spencer. Lonoke County sits in the flat farmland of central Arkansas, a rural stretch of small towns and gravel roads where neighbors tend to know each other's business and news travels fast. It is the kind of place where a family can live for years without much contact with the criminal justice system, and where a case involving a child can shake a community in a way that lingers long after the headlines fade. This is where, in the fall of 2024, a father's search for his missing daughter turned into a case that would draw national attention and, eventually, put him at the center of a political campaign as well as a murder trial. Aaron Spencer and his wife Heather were raising their family in Lonoke County, living what by most accounts was an ordinary rural life. Their daughter was 13 years old in the summer of 2024, when the family's world began to change. According to accounts later shared by Heather Spencer, the family became aware that their daughter had been the target of grooming and abuse by a man connected to a family friend. That man was Michael Fossler, 67 years old at the time, who lived in the same community and had, according to the family, worked his way into a position of trust around their daughter before the abuse began. In July 2024, the family learned what had happened, and the matter was reported to authorities. Fossler was arrested and indicted on a lengthy list of charges, ultimately facing 43 separate felony counts. These included sexual assault of a minor, internet stalking of a child, and possession of child pornography, among other offences connected to his conduct towards Spencer's daughter. Fossler pleaded not guilty in September of that year. Despite the severity and number of charges against him, he was released from custody after posting $50,000 in bond, with a court order in place barring him from any contact with the girl. For a family that had just learned their daughter had been groomed and abused, the sight of the accused man walking free, even under a no-contact order, was difficult to accept. Heather Spencer later described the family's mindset in the months that followed, saying they had chosen to trust the legal process, believing that with dozens of charges pending, justice would eventually be served through the courts. That trust would be tested only a few months later. On the night of October 8, 2024, the Spencer household was disturbed by the sound of their daughter's small dog barking urgently in the dark. Aaron Spencer got up to check on the source of the commotion and went to look in on his daughter. At first glance, her bed appeared occupied, but a closer look revealed that what looked like her sleeping form was in fact a stuffed animal, arranged inside her hoodie to create the impression that she was safely asleep. His daughter was gone. Spencer and his wife immediately began searching the house and the property. According to court documents and news accounts, Heather called 911 to report their daughter missing, while Aaron got into his truck and began driving through the area, searching for any sign of her. He did not have to search long. He soon spotted a truck belonging to Michael Fossler on a nearby road, with his daughter visible inside the passenger seat. What happened next has been described in different ways by different parties, and many of the specific details remain contested as the case has moved through the courts. According to accounts from Spencer's family, once Fossler realized Spencer was behind him, he attempted to flee. A pursuit followed, ending when Fossler's vehicle was involved in an accident. Spencer was able to reach his daughter and get her out of the vehicle alive. During the encounter, according to the family's version of events, Spencer was attacked by Fossler and responded by shooting him in what he believed was necessary to protect himself and his daughter. Prosecutors have offered a different account, alleging that Spencer had expressed intentions to kill Fossler even before the night of the shooting, based in part on comments he made in the aftermath of learning about the abuse back in July. They have also pointed out that Spencer had the opportunity to call law enforcement during the pursuit, rather than continuing to chase Fossler's vehicle himself. Spencer called 911 after the shooting to report what had happened. According to the responding dispatch record, he told the operator that the man who had taken his daughter was dead on the side of the road, adding that he had no choice but to act as he did. Authorities have not confirmed publicly whether Fossler was armed during the encounter. What is clear is that Fossler died at the scene, and Spencer was subsequently arrested and charged with second-degree murder, with an additional firearm enhancement that increases the potential sentence when a weapon is used in the commission of a crime. The community's reaction to Spencer's arrest was immediate and largely sympathetic to the father. Word spread quickly through Lonoke County and then across the country as the story picked up national media coverage. A petition calling for the charges against Spencer to be dropped gathered more than 350,000 signatures. A gun rights organization in the state publicly declared his actions justified and helped establish a legal defense fund on his behalf. When the fundraising platform GoFundMe removed an earlier campaign related to the case, citing its policy against fundraising for the legal defense of people charged with violent crimes, the community responded by setting up an alternative fund through another platform to continue supporting the family. Heather Spencer became a visible presence throughout the case, speaking to reporters and posting updates about the toll the situation had taken on her family. She described a life that had been upended, saying that where her days were once filled with ordinary domestic routines, they had become consumed by therapy appointments, legal proceedings, and the constant effort to keep her husband home with his family while the case moved forward. She spoke about the outpouring of support the family received from people in their community and from strangers who had followed the story, saying it had made an unbearable situation feel less isolating. The legal proceedings that followed were unusually contentious for what might otherwise have been a straightforward, if tragic, criminal case. The presiding judge, Circuit Judge Barbara Elmore, issued a gag order early in the case that barred nearly everyone connected to it, including attorneys, witnesses, and family members, from speaking publicly about the details under threat of contempt of court. The order was broad enough that it drew scrutiny well beyond the immediate parties involved. The Arkansas Supreme Court eventually intervened and struck down the gag order, describing it in its ruling as a clear and significant abuse of judicial discretion that exceeded the court's authority. The reversal was seen by Spencer's supporters as a vindication of concerns that the case was being handled in a way that limited public scrutiny of decisions being made by local prosecutors and the court. Spencer's defense attorney, Erin Casanelli, has argued publicly that her client's actions were consistent with what any father would do to protect his child from harm, and has suggested that the prosecution's handling of the case reflects poor judgment on the part of local officials rather than a fair application of the law. Prosecutors have maintained that regardless of the circumstances that led to the confrontation, the decision to continue pursuing Fossler rather than involve law enforcement, combined with statements Spencer made in the weeks after learning of the abuse, point to intent rather than a purely defensive reaction in the moment. As the case continued to draw attention through early 2026, it took an unusual turn when Aaron Spencer entered the Republican primary race for Lonoke County Sheriff while still awaiting trial on the murder charge. Running on a platform that criticized what he described as failures within local law enforcement and the justice system, Spencer defeated the sitting sheriff in the primary election, according to unofficial results from the Arkansas Secretary of State's office. Legal experts noted the unusual position this created, since a conviction on the pending murder charge would disqualify him from serving in the office even if he won the general election. Spencer's attorney maintained that the outcome of the election had no bearing on the facts of the underlying case, and that at some point those responsible for prosecuting her client would have to reckon with the position they had put a father in. As of the most recent reporting, the criminal case against Aaron Spencer remains unresolved, with the murder charge still pending and no trial date confirmed in the available public record. The case continues to be closely watched, both as a legal matter testing how Arkansas courts will weigh a parent's claimed defense of a child against the deliberate choices made in the mile between the moment Spencer left his home and the moment he pulled Fossler's truck off the highway, and as a broader flashpoint in the ongoing debate about how the justice system should treat parents who intervene when they believe the law has already failed their children once. What makes the Spencer case distinct from many of the others on this list is that it remains, at the time of this recording, an open and contested legal matter rather than a settled piece of history. The facts that will ultimately determine Spencer's fate, including the exact sequence of events on that October night and the question of what was in his mind before he ever got into his truck, are still being argued in court. Whatever the outcome, the case has already become another entry in a long and difficult pattern, one in which a parent, faced with a system that moved slower than the danger to their child, chose to act on their own and left it to a courtroom and a community to decide what that choice should cost him. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. A father in Arkansas still waits for a verdict that hasn't come. Next, the story moves to a Louisiana airport in 1984, where television cameras would capture a different father's answer to the same impossible question. Case 4. Gary Plauché, Baton Rouge, sits along a wide bend of the Mississippi River, a capital city built around government buildings, refineries, and a slower southern pace that made national headlines an unusual thing for the community in the early 1980s. It was here, in March of 1984, that a father's private torment played out in front of television cameras, in one of the earliest instances of a violent act of parental revenge being captured live and broadcast to homes across the country. Gary Plauché was a Baton Rouge native, separated from his wife June at the time, raising his son Jody largely on his own. Jody was 11 years old and had taken up karate lessons at a local studio, a hobby that seemed, at the time, like an ordinary part of childhood. The instructor at that studio was a man named Jeff Doucette, who over the course of many months built a close relationship with Jody, one that outwardly looked like mentorship, but was, according to later investigations, a calculated pattern of grooming. Doucette had positioned himself as more than an instructor. Court records and later psychological evaluations described him as someone skilled at manipulating trust, someone who took advantage of the fact that Gary Plauché was separated from his wife, and that Jody, as a result, had a gap in his life that Doucette worked to fill. Doucette became a fixture in the family's routine, someone the Plauchés had come to see as a friend rather than a threat. In early 1984, Doucette kidnapped Jody and took him across the country to California, ultimately traveling as far as Disneyland in Anaheim. During this time, according to investigators, Doucette sexually assaulted the boy repeatedly. What should have been a carefree trip to an amusement park for any other family became, for Jody, a period of captivity and abuse carried out by someone his family had trusted completely. Federal investigators tracked Doucette down before the trip went further, and he was arrested. Jody was recovered safely and returned to his father. For a brief window, it must have felt to Gary Plauché as though the worst of the ordeal was over, that his son had been found and the man responsible was now in the hands of the law. That sense of relief did not last. A sheriff's major who had helped track down Doucet and who was friendly with Plauché took it upon himself to tell the father what exactly had happened to his son during the time he was missing. According to that officer's later account, Plauché reacted the way most parents do upon learning their child has been raped. He was horrified, and in the heat of that moment, told the officer he intended to kill the man responsible. In the days that followed, as Doucet awaited extradition back to Louisiana to face kidnapping charges, Plauché remained deeply unsettled. He spent time at a local bar called the Cotton Club, where he was known to regulars, and he began asking people around him when they thought Doucet might be returned to Baton Rouge to stand trial. A former colleague from a local television station happened to be at the bar one evening and mentioned, in passing, that Doucet was scheduled to be flown back into Baton Rouge on American Airlines Flight 595, arriving at the Metropolitan Airport on March 16th. On the day of the flight, Plauché drove to the Baton Rouge airport. He wore a baseball cap and sunglasses, and he carried a snub-nosed .38 caliber revolver in his boot. He positioned himself near a bank of payphones in the arrivals area, where he made a call to a friend. According to that friend's later account, Plauché told him that Doucet's flight had arrived, warning him that he was about to hear a gunshot. He kept the phone line open as he watched Doucet, in handcuffs, being escorted through the terminal by a sheriff's deputy. As Doucet passed by, Plauché turned, drew the revolver, and fired a single shot. The bullet struck Doucet, who collapsed and later died from his injuries. A local television news crew happened to be filming in the terminal at the time, capturing the moment on camera, footage that would later be broadcast repeatedly across the country as the case gained national attention. After firing the shot, Plauché did not attempt to flee. He dropped the weapon, hung up the phone, and waited to be taken into custody. When officers asked him why he had done it, he offered a simple response, one that would be quoted for years afterward, saying that if someone did that to another person's child, they would do the same thing. Plauché was initially charged with second-degree murder. As the case moved forward, his defense team built an argument centered on his mental state at the time of the shooting. A psychiatrist who examined him, Dr. Edward Uzzi, concluded that Plauché had entered what he described as a temporarily psychotic state upon learning the details of what Doucet had done to his son, one in which he was unable to distinguish clearly between right and wrong in the moment he pulled the trigger. Uzzi's evaluation also detailed how skillfully Doucet had manipulated his way into the Plauché family, using the instability created by Gary and June's separation to gain unusual access to Jody over an extended period, a pattern that helped explain, to the psychiatrist at least, how deeply the betrayal had cut. Public opinion in Baton Rouge overwhelmingly supported Plauché. Neighbors and acquaintances described him as a man who had acted not out of malice, but out of love for his son and a father's sense of duty. A riverboat captain named Murray Curry, who lived near Plauché, told a reporter that in his eyes, this was a father who had done what he did out of love for his child and for his own pride, not out of a desire to hurt anyone else. Local residents contributed to a defense fund that helped Plauché cover the $100,000 bail he had been required to post, allowing him to remain with his family while the case worked its way through the courts. Given the weight of public sympathy and the psychiatric findings presented by the defense, Plauché eventually agreed to a plea arrangement, pleading no contest to manslaughter rather than facing a trial on the more serious murder charge. When it came time for sentencing, the presiding judge, Frank Sire, decided against sending Plauché to prison. The judge stated that incarcerating Plauché would serve no useful purpose, noting that there was essentially no risk that Plauché would ever commit another violent act. Plauché was given a 7-year suspended sentence, 5 years of probation, and an order to complete 300 hours of community service, all of which he fulfilled by 1989. In the years that followed, Gary Plauché and his son worked to rebuild something resembling a normal family life. Jody has spoken publicly about how complicated his feelings were in the immediate aftermath of the shooting. As a child, he had genuinely cared for Doucet, viewing him as a mentor and friend, before understanding the full extent of what had happened. And he later admitted that he initially felt some anger toward his father for what he had done. Over time, as Jody grew older and came to a fuller understanding of the grooming and abuse he had experienced, his perspective shifted. He went on to attend Louisiana State University, where he became involved with an organization called Men Against Violence, and after graduating, he worked at a victim services center, providing support to survivors of sexual assault. He would later describe his relationship with his father as one defined not by that single violent act, but by a lifetime of care, at one point calling him the greatest father anyone could ask for. In 2019, Jody published a book about his experience, offering his account of the kidnapping and its aftermath, in the hope that it might help other families recognize warning signs before a similar tragedy could occur. Gary Plauché lived for 3 more decades after the shooting, a period largely out of the public eye compared to the intensity of the case's initial coverage. He suffered a stroke in 2011, and after a second stroke in 2014, he died in a nursing home at the age of 68. His obituary described him as a man who saw beauty in the world around him, someone who was a loyal friend, and someone who made the people around him laugh, alongside the more complicated legacy that followed him from that day at the airport. The Plauché case remains one of the most referenced examples in American legal history of the tension between the formal justice system and a parent's raw response to learning their child has been harmed. Unlike cases where the outcome remains contested or the underlying facts are murky, the events of that day in the Baton Rouge airport were captured on film, viewed by millions, and never seriously disputed. What has remained a matter of debate for decades since is not what happened, but what it meant that a community, a judge, and eventually the broader public largely agreed that a father should walk free after killing the man who had hurt his son, a conclusion that continues to raise uncomfortable questions about where the line between grief and justice is meant to be drawn. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. A single gunshot in a Louisiana airport terminal, captured on camera and replayed for a nation. Next, the story moves to a rural Texas road, where a father's grief over his 2 sons would collide with a case built on shadows and missing evidence. Case 5. David Barajas, Alvin, Texas, sits about 30 miles southeast of Houston, a small town surrounded by flat farmland and quiet rural roads, where the distance between neighbors is often measured in acres rather than blocks. It is the kind of place where a family walking home along the shoulder of a road late at night would expect nothing more dangerous than the dark itself. In December of 2012, that expectation was shattered in a matter of seconds, and what followed became one of the more legally complicated cases of a parent accused of retaliatory violence in recent American history. David Barajas was 31 years old, a father raising 4 children with his wife in the area around Alvin. On the night of December 7th, the family's pickup truck ran out of gas on a rural road not far from their home, close enough that Barajas decided the fastest solution was simply to push the vehicle the rest of the way rather than wait for help. He was joined by his 2 oldest sons, 12-year-old David Jr. and 11-year-old Caleb, both of whom were known in the community as fans of the Houston Texans football team. The boy's mother and 2 younger siblings remained inside the truck as Barajas and his sons pushed it along the shoulder of the road, only about 100 yards from home. As they worked to move the disabled truck, a car approached. Behind the wheel was 20-year-old Jose Banda, who was later found to have been driving while intoxicated. Banda's vehicle struck the group, hitting Barajas and both of his sons. David Jr. was killed at the scene. Caleb was rushed to a hospital, where he later died from his injuries. Barajas himself survived the collision, though accounts from the scene describe him as covered in his son's blood as he attempted to perform CPR in a desperate effort to save them before help arrived. What happened in the chaotic minutes after the crash became the central and most contested question of the case that followed. According to witnesses at the scene, cited later by prosecutors, Barajas left the area briefly, reportedly walking toward his nearby home, before returning several minutes later. Emergency dispatch records established a tight timeline that would later become critical to the case. The first 911 call reporting the crash came in at 11:33 p.m. A child was reported dead 1 minute later at 11:34 p.m. Gunshots were then heard at 11:35 p.m. before police arrived and cleared the scene for paramedics at 11:40 p.m. Jose Banda was found shot in his wrecked car. He died from his injuries at the scene. More than 2 months passed before charges were filed. In February of 2013, a grand jury indicted Barajas on a charge of murder in connection with Banda's death, and he was taken into custody with bond set at $450,000. Investigators alleged that in the chaos following the crash that killed his sons, Barajas had gone home, retrieved a firearm, and returned to the scene of the wreck to shoot the driver responsible. A search of his home turned up a holster and ammunition consistent with the type of weapon believed to have been used, though the gun itself was never recovered by investigators, despite an extensive search. The case that followed was unusual in how much its outcome hinged on the absence of direct evidence rather than its presence. No witness ever identified Barajas as the person who fired the fatal shots. Gunshot residue testing performed on his hands and clothing came back negative, a result that would ordinarily be expected if he had recently discharged a firearm, although such tests are not always conclusive, depending on the circumstances of exposure and cleanup. A forensic scientist did testify that blood found on the driver's side door and armrest of Banda's wrecked car was consistent with Barajas's own blood, which prosecutors argued placed him at the vehicle after the crash, though the defense noted that this was consistent with a grieving father checking on the person who had just killed his children, not necessarily evidence of a shooting. At trial, prosecutor Brian Harak argued to the jury that whatever pain Banda's reckless decision to drive drunk had caused, he did not deserve what amounted to a public execution on the side of the road. The state's case rested heavily on circumstantial evidence and timeline analysis, suggesting that Barajas had the opportunity and, given the ammunition and holster found in his home, plausibly the means, to carry out the shooting during the narrow window between the initial crash and the arrival of police. Barajas's defense attorney, Sam Kamek, worked to dismantle that narrative piece by piece. He told the jury that his client had never left the crash site at all, and that the entire time investigators claimed Barajas was retrieving a weapon, he had in fact remained with his dying sons, trying desperately to save them. Kamek introduced evidence suggesting an alternative explanation for Banda's death, pointing to blood from a third, unidentified person found inside Banda's vehicle. He argued to the jury that Banda, who had documented gang affiliations according to the defense's characterization, may have been the target of an entirely separate shooting connected to that other, unidentified individual, rather than someone hunted down by a grieving father. Kamek also called attention to testimony suggesting that additional gunfire had been heard well after the shots that killed Banda, raising the possibility that another shooter remained unaccounted for at the scene. He further noted that Barajas had never owned a firearm, challenging the state's theory that ammunition and a holster found in the home tied him directly to the killing. The trial drew significant attention in the small community around Alvin, with dozens of friends and family members from both the Barajas and Banda families packing the courtroom throughout the proceedings, some wearing buttons memorializing the two boys who had died. The presiding judge, Terry Holder, ultimately asked that such buttons be removed before opening statements, expressing concern that visible displays of grief or support might improperly influence the jury in a case that was, in her words, difficult for everyone involved, given that all parties in the room had lost someone they loved. After a trial that lasted about a week, the jury deliberated for approximately 3 hours before returning a verdict of not guilty. Following the acquittal, the lead prosecutor on the case, Jerry Yenny, spoke to reporters and stated that she continued to believe Barajas had killed Banda, explaining that the state would not have brought the case forward otherwise. She acknowledged, however, that the jury had not found the evidence sufficient to prove that belief beyond a reasonable doubt, and said she respected the verdict despite disagreeing with it personally. For Barajas, the verdict brought a measure of relief without resolving the deeper loss at the center of the case. Speaking to reporters after the trial, he described feeling as though a significant weight had been lifted, while also making clear that his sons' deaths remained an unhealed wound that no legal outcome could touch. He extended sympathy to Banda's family as well, acknowledging that whatever the jury had decided about the shooting, another family had also lost someone that night, and that in his eyes, everyone involved in the tragedy had suffered a loss. The Barajas case stands apart from many others in this list because it never definitively established who killed Jose Banda or under what precise circumstances. Unlike cases built on confessions, courtroom footage, or an accused parent's own account of a killing, the legal record here remains, formally, an acquittal rather than an admission. What is not in dispute is the human core of the story. A father, in the space of a single night, watched a drunk driver take the lives of his two young sons on a dark road just steps from their home, and within minutes, that same driver was dead. Whether Barajas pulled the trigger himself, whether some other unidentified person was responsible, or whether Banda's associates settled some unrelated score that same night, the case left behind a community divided over sympathy for a grieving father and unease over a killing that, to this day, remains formally unsolved in the eyes of the law. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. A jury clears a father of a killing the evidence could never quite prove, leaving a small Texas town to draw its own conclusions. Next, the story moves to Alabama, where another father would wait 13 years before delivering the reckoning he had never stopped planning. Case 6. The Alabama Father and Raymond Brooks. Cullman County lies in the hill country of north-central Alabama, a rural stretch of small towns, timberland, and back roads where a person's reputation tends to follow them for life, passed along through churches, diners, and family gatherings rather than through any official record. It is the kind of place where a crime committed against a child does not simply fade from memory over the years, even after a conviction, even after a prison sentence has been served in full. It waits, sometimes for over a decade, until the people affected by it are forced to confront it again, often in a place and a manner no one could have predicted when the original crime first came to light. The case begins with a young girl, identified in later reporting only through her own account as an adult, who described years of abuse she endured as a child, beginning around the age of 4 and continuing until she was roughly 8 years old. She would later tell reporters plainly and without embellishment that a man named Raymond Earl Brooks had molested her for 4 or 5 years during that formative stretch of her childhood, a length of time that meant the abuse was not an isolated incident, but a sustained pattern woven into her earliest memories. Brooks was a registered sex offender by the time the case drew renewed attention, a status tied directly to his conviction stemming from what he had done to her. At some point during those years, or in the period following them, the abuse came to light, and Brooks was prosecuted. He was convicted of his crimes against the girl and sentenced to serve time in an Alabama prison, a legal resolution that, on paper, represented the system working as it was designed to. Charges were filed, evidence was presented, a conviction was secured, and a punishment was handed down. For the girl and her family, this should have marked the end of the ordeal, at least in terms of the formal legal process. In practice, a criminal conviction and prison sentence rarely erase the underlying harm. They simply close one chapter while another, quieter one continues indefinitely in the lives of survivors and the people who love them. Brooks eventually completed his sentence and was released from custody. Under Alabama law, as in most states, his release required him to register as a sex offender, a status that comes with ongoing reporting requirements and restrictions intended to allow both law enforcement and members of the public to track the whereabouts of individuals convicted of these crimes. Brooks complied with these requirements and returned to live in the same general area where his crimes had originally taken place, a decision that, whatever the legal justification behind it, placed him back within reach of the community and, by extension, the family he had harmed years earlier. For the girl's family, Brooks's return to the area was not simply a bureaucratic notation on a public registry. It meant that a man who had caused years of documented harm to their daughter was once again living nearby, walking the same roads, shopping at the same stores, potentially crossing paths with the very people whose lives he had altered so profoundly. Registries exist, in part, to allow communities to be aware of this kind of proximity, but awareness does not necessarily bring peace of mind. If anything, for a family already carrying the weight of what had happened, knowing exactly where their daughter's abuser now lived, and being reminded of his presence through the ordinary mechanics of small-town life, likely reopened wounds that the original conviction had never fully closed to begin with. Years passed in this uneasy proximity. By 2015, more than a decade had gone by since Brooks's initial conviction, and roughly 13 years had passed since his release from prison. Whatever tension had existed beneath the surface of that arrangement, between a convicted offender quietly living out his post-prison life and a family that had never stopped carrying the effects of what he had done, it finally reached a breaking point that summer, in a manner that had little apparent connection to any recent, specific triggering event beyond the accumulated weight of the years themselves. According to sheriff's officials in Cullman County, the events unfolded near a country store in the small community of Berlin, Alabama, a rural crossroads typical of the region. A man riding a motorcycle, believed by investigators to be the father of the girl Brooks had abused, opened fire outside the store. His apparent first target was not Brooks at all, but a different man entirely, someone reportedly dating the father's stepdaughter. That intended target managed to escape by running into the store and hiding, avoiding the gunfire directed at him. Investigators later stated that they were unable to establish any known connection between this fleeing man and Raymond Brooks, and it remained unclear, even to law enforcement examining the scene afterward, precisely what had triggered the shooting to begin with, or why two seemingly unrelated confrontations appeared to be converging in the same place at the same time. In the midst of this chaotic scene, Raymond Brooks himself was shot and killed. Chief Deputy Max Bartlett, speaking to reporters in the aftermath, acknowledged that there was clearly a history of animosity between the father and Brooks, using the phrase that the two men obviously did not have a lot of good blood between them, an understated way of describing a relationship shaped by the abuse Brooks had inflicted on the man's daughter years earlier. Bartlett stopped short, however, of confirming definitively whether the shooting of Brooks was a direct and intentional act tied to that abuse, or whether it emerged in some more chaotic and less linear fashion out of the broader confrontation taking place outside the store that day. He noted, somewhat cryptically, that the father appeared to be dealing with significant personal stressors in the period surrounding the incident, describing the overall situation as odd, without elaborating further on what exactly he meant by that assessment, or how those stressors might have connected to the events of that day. The ambiguity captured in Bartlett's comments reflects something important about this case relative to others explored throughout this list, where cases like Gary Plochet's or Ellie Nessler's involve a single, clearly intentional act directed unambiguously at a specific person for a specific and well-documented reason. The events outside that country store in Berlin, Alabama, resist such a clean narrative. There appear to have been at least two separate potential targets that day, one who escaped unharmed and one who did not survive, and the precise sequence connecting the father's apparent confrontation with his stepdaughter's boyfriend to the death of Raymond Brooks, a man with no evident connection to that other man, was never fully clarified in public reporting on the case. The father was arrested and charged with murder in connection with Brooks's death. As the case made its way through the legal system, it drew public attention and, from many corners, sympathy rooted not in the specific and murky circumstances of the shooting itself, but in the broader, publicly known fact underlying it, that Brooks had spent years molesting the man's daughter when she was a small child, and that whatever chaos had unfolded outside that store, the man ultimately responsible for pulling the trigger on Brooks was someone whose family had already suffered greatly at Brooks's hands, long before that day ever arrived. Thousands of people across the region and beyond expressed public support for the father as news of the case spread, a reaction that echoed a pattern seen repeatedly throughout this list, where a parent's underlying grievance, however violently or chaotically it eventually expressed itself, generated public sympathy that often ran ahead of, or even directly against, the formal findings and charges brought by prosecutors. The case eventually proceeded to sentencing, following legal proceedings that had to weigh several complicated and sometimes conflicting factors. On one side stood the documented extensive abuse Brooks had inflicted on the man's daughter over a period of years, a fact that was never disputed and that had already been established through Brooks's original conviction. On the other side stood the reality that the killing itself occurred more than a decade after that original case had concluded, well outside the kind of immediate, heat-of-the-moment circumstances that have sometimes led courts toward more lenient treatment in similar cases elsewhere on this list, such as the near-total leniency extended to Gary Plauché, or the grand jury's decision not to indict the father in China, Texas. Compounding the complexity further was the unresolved ambiguity around the shooting itself, the presence of a second, unrelated apparent target that day, and the uncertainty officials expressed about how directly the killing connected to the original abuse versus whatever other tensions or stresses the father may have been experiencing. The gap between the abuse and the killing became a significant and unavoidable factor in how the case was ultimately viewed by the legal system. A response that might be characterized as an understandable, if illegal, reaction to fresh and immediate trauma looks fundamentally different to a judge and jury when it follows years of quiet, outwardly stable coexistence in the same small community after the legal system had already run its full course once, delivering a conviction and a completed prison sentence for the original crime. Courts across the country have, at various points, shown a degree of leniency toward parents acting in the raw, immediate aftermath of discovering harm to their child, reasoning that such actions, however illegal, emerge from an emotional state the law recognizes as meaningfully distinct from calculated, premeditated violence carried out with time for reflection. Here, more than a decade had passed since that immediate aftermath had come and gone, time during which the formal justice system had already delivered its verdict and its sentence, and Brooks had already paid whatever price the law had determined was appropriate for his crimes before ever returning to the community where he was ultimately killed. For the girl at the center of the underlying case, now an adult reflecting publicly on what had happened to her as a child, the years since Brooks's original conviction and release had clearly not erased the impact of what she endured. Her willingness to speak plainly about her experience, describing without hesitation what Brooks had done to her over those formative years of her life, underscored a reality that runs through many of the cases explored in this list. The legal system's formal timeline of arrest, trial, sentencing, and eventual release does not necessarily align with a survivor's own timeline of healing, nor with a parent's private sense of when a threat to their family has genuinely passed. For this family, Brooks's release and his decision to return to live in the same community apparently reopened a wound that his original conviction and imprisonment had never fully closed, at least not in any way that outwardly resolved the tension between the two families living in proximity to one another for over a decade. The case remains a genuinely difficult one to categorize alongside the others explored in this list, most of which involve either an immediate, single-moment confrontation or a documented, singular decision made in direct response to a clearly established threat. The passage of so many years between Brooks's crimes and his death, combined with the unresolved questions surrounding the second apparent target that day and the broader ambiguity officials expressed about what exactly triggered the violence, raises different and less easily answered questions than most of the other cases here. It asks what obligation, if any, a community or a justice system owes to a survivor and her family once a convicted offender has served his sentence in full and chosen to return to live among the same people he once harmed. It asks what happens to a parent's sense of protective duty and unresolved grief when the formal chapter of a case has closed years earlier in the eyes of the law, but the emotional one clearly never did, for either the survivor or the family surrounding her. And it raises the further, more troubling question of what it means when even the precise motivations and target of a violent act become difficult to fully establish after the fact, leaving investigators, prosecutors, and the public alike to draw their own conclusions from incomplete information about exactly what unfolded outside that country store. Whatever the precise chain of events and motivations behind the shooting in Berlin, Alabama, the case stands as one of the starker and more ambiguous examples in this list of how long the aftershocks of childhood abuse can travel through a family, resurfacing not necessarily in the clean, contained panic of a single terrible night immediately following a discovery of harm, but in the quiet, accumulated weight of over a decade, converging finally with other tensions and stresses, in a moment that even the officials investigating it struggled to fully untangle or explain. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. 13 years of quiet coexistence end in a confrontation officials themselves struggled to fully explain. Next, the story moves to the Pacific Northwest, where a man's fear for children he had never even met would end in 2 separate killings, 2 mornings apart. Case 7, Patrick Drum Sequim, is a small town on Washington's Olympic Peninsula, tucked between the towering ridgeline of the Olympic Mountains and the cold waters of the Strait of Juan de Fuca, a community more commonly associated with its lavender farms and its mild, rain-shadowed climate than with violent crime. It is the kind of place where residents often move specifically to get away from the pace and unpredictability of larger cities, drawn by the promise of a quieter life. In the summer of 2012, that quiet was broken by a case that did not involve a father protecting his own child from a known and specific abuser, but a man who described himself as acting on behalf of children he had never met, based entirely on the criminal histories of 2 of his own acquaintances. Patrick Drum was 34 years old and living near Sequim at the time of the killings. He was acquainted with 2 men in the area, both of whom were registered sex offenders under Washington state law, a status that placed their names and general whereabouts on a public registry maintained specifically so that communities could remain informed about individuals convicted of sexual offenses. Gary Lee Blanton was 28 years old and carried a conviction for 3rd-degree rape dating back to when he was still a juvenile, a conviction that, under Washington's registration requirements, followed him into adulthood regardless of how many years had passed since the offense itself. Jerry Wayne Ray was considerably older, 57 at the time, and was also registered as a Level 2 offender, a classification used by the state to indicate that an individual was assessed as presenting a moderate risk of reoffending, a middle tier between the lowest and highest risk categories used in Washington's registration system. Drum shared a home with Blanton at the time these classifications applied to the man he lived alongside, a detail that placed him in unusually close and regular proximity to at least one of the 2 men he would go on to kill. On June 2, 2012, Drum shot and killed Blanton inside the home the 2 men shared, an act that took place not in a public confrontation or a chance encounter, but within the walls of a residence the 2 had been sharing, under circumstances that suggest at least some degree of premeditation, given the domestic setting involved. The following morning, Drum traveled to confront Jerry Wayne Ray and shot him as well, killing him in a separate incident carried out roughly 24 hours after the first. Drum did not attempt to conceal his involvement in either killing or flee the area in the aftermath. When he was eventually taken into custody, he did not deny responsibility. Instead, when he came to address the court directly, he offered an explanation for his actions rooted not in revenge for any specific harm done to a child of his own, since no such child or specific incident was ever identified in connection with either victim, but in a broader, more generalized desire to prevent potential future harm to children he believed the 2 men might otherwise go on to victimize, given their existing convictions and their classification under the state's registry system. At his sentencing in September of that year, Drum showed little inclination toward remorse for the killings themselves, even as he acknowledged some measure of regret for the broader suffering his actions had caused to people beyond his 2 victims. Addressing the grief experienced by the men's families, Drum described the pain he had caused them in a notably clinical way, characterizing it in his own words as collateral damage that he did feel bad about, language that framed the suffering of the victims' relatives as an unfortunate but ultimately secondary consequence of what he still seemed to view as a necessary and justified set of actions. He was careful, in the same breath, to distinguish that specific regret over collateral suffering from any regret over the killings themselves. Referring directly to the 2 men he had killed, he told the court that actions speak louder than words, a statement that suggested he continued to view their past convictions, regardless of the time that had passed since those convictions were handed down, or any evidence, or lack thereof, of continued offending in the years since, as sufficient justification for what he had done to both of them. The case drew a mixed and sharply divided public reaction that echoed, though did not fully mirror, the sympathy commonly extended in cases involving parents avenging documented harm already done to their own children elsewhere in this list. Some members of the public and online commentators viewed Drum as something close to a vigilante hero, a private citizen willing to take direct and decisive action that the justice system, in his view and in theirs, was not adequately taking on its own to protect children broadly from men carrying histories of sexual offences, regardless of whether those men had shown any specific sign of reoffending in the period leading up to their deaths. Others took a starkly different view, seeing Drum as a man who had effectively appointed himself judge, jury, and executioner over two individuals who, whatever the seriousness of their past convictions, had already been processed through the legal system, had served whatever sentence the courts determined was appropriate for their crimes, and had not, at the time Drum killed them, been shown through any new charge, arrest, or documented incident to pose an active or imminent threat to any specific, identifiable child. Leslie Blanton, a family member connected to Gary Lee Blanton, spoke directly to the court during Drum's sentencing hearing, offering testimony that added a deeply human dimension to a case that might otherwise be discussed largely in the abstract terms of public safety and risk assessment. She described, in painful detail, the moment her young children discovered their father's body after Drum shot him inside the home the two men shared, a detail that underscored just how far the ripple effects of Drum's actions extended beyond the two men he had specifically targeted, reaching into the lives of children who had no connection whatsoever to whatever risk Drum believed Blanton and Ray posed to society at large. She also told the court that in the aftermath of the killings, some of Drum's supporters had gone so far as to harass her directly outside her own home, a detail that served as a pointed reminder that public sympathy for a self-appointed protector of children can carry its own set of consequences for the families left behind in the wake of that protector's actions, families that, in this particular case, included young children belonging to the very men who had been killed in the name of protecting children more broadly. Drum was ultimately sentenced to life in prison without the possibility of parole, a considerably harsher outcome than the sentences handed down in several of the other cases explored throughout this list. The disparity between Drum's sentence and the more lenient outcomes seen in cases like Gary Plauchet's probation or the eventual limited prison time served by Ellie Nessler reflects an important and consistently applied legal distinction that runs throughout the broader pattern this list has traced. Unlike parents who acted in the direct, immediate aftermath of learning that their own specific child had been harmed by a specific individual, often citing an overwhelming, personal, and particularized grief as at least a partial mitigating explanation for their actions in the eyes of courts and juries, Drum's killings were premeditated, carried out against two separate men on two separate occasions roughly a day apart, and grounded not in any specific act of harm committed against a child he personally knew, but in a generalized fear rooted entirely in what these men, given their existing histories, might conceivably go on to do to children they had not yet harmed, and whose identities, if such children existed at all, were never established. Courts across the country have historically shown some measure of leniency toward parents acting on immediate, personal, and specific grief in the direct wake of a documented crime against their own child. Drum's case offered no such immediate, personal, or specific connection to justify his actions, and the length and severity of his sentence reflected that critical difference sharply and unambiguously. Drum's case is included in this list not because he was a parent avenging his own child in the manner of so many of the other stories explored here, but because his stated motivation, the desire to protect children broadly from men he believed the justice system had failed to sufficiently restrain or monitor, sits at the far outer edge of the same underlying impulse that drives many of the other cases in this list forward. It raises a distinct and genuinely uncomfortable question that the courts, in Drum's case, answered with unusual clarity and severity. If society is willing to extend some measure of understanding, if not outright approval, to a parent who kills the specific man who harmed their specific child, does that same underlying reasoning extend just as readily to someone acting preemptively, on behalf of children who have not yet been harmed at all, based solely on a person's existing criminal record and a generalized fear of what they might do again at some undetermined point in the future? The courts in Drum's case answered that question unambiguously in the negative, treating his actions as calculated, premeditated killings rather than an understandable, if illegal, response to an immediate and deeply personal tragedy, and sentencing him accordingly to spend the remainder of his life behind bars without any possibility of parole. The case also highlights a broader tension that runs beneath many stories involving registered sex offenders attempting to reintegrate into their communities after having already served their sentences under the law. The families of both Blanton and Ray were left to grapple not only with sudden, violent and unexpected loss, but with a public conversation that, in many corners of both local and national commentary, offered more open sympathy to the man who had killed their relatives than to the men who had been killed themselves, regardless of whether either man had shown any indication of reoffending in the specific period of time leading up to his death. Drum's own words at sentencing, carefully distinguishing between a measure of regret for the pain experienced by the surviving families and a complete absence of regret for the killings themselves, captured the deeply uneasy space this particular case occupies within the broader pattern this list has traced. A space where the language of child protection was invoked to justify a pair of premeditated killings against two men who, whatever the troubling nature of their pasts, had already been processed once through the very legal system Drum ultimately decided to bypass entirely, and who were not, at the moment Drum decided to act, known to have committed any new offence against any specific child. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. 2 killings, 2 mornings apart, leave a small Washington town divided over what protection is supposed to look like. Next, the story moves to Nebraska, where a stranger's anonymous email to a newsroom would unravel a killing rooted in one family's private reckoning with abuse. Case 8, James Fairbanks, Omaha, Nebraska, is a city built along the banks of the Missouri River, a place of quiet residential neighborhoods and mid-sized suburbs where most families expect their block to remain, above all else, safe for their children. In the summer of 2021, that expectation was upended in a case that stood apart from many others in this list, not because a parent avenged harm already done to their own child, but because a man who was not the victim's parent took it upon himself to act, driven by fear for children he believed were still at risk. Matteo Condalucci was a man with a documented history of sex crimes against children. His conviction and the details surrounding it were known within his community, and his own family was directly touched by his past. His daughter, Amanda Henry, would later speak publicly about her own experience, telling reporters that she herself had been raped by her father, a disclosure that placed her at the center of a case that already carried enormous emotional weight before it reached its violent conclusion. James Fairbanks lived in the Omaha area and had some level of awareness of Condalucci's history as a convicted sex offender. According to prosecutors, Fairbanks made the decision to go to Condalucci's home and confront him directly. What followed was a shooting that left Condalucci dead. Fairbanks did not immediately come forward to authorities. Instead, in the days after the killing, he sent an anonymous email to several local media outlets, including a station in Omaha, in which he confessed to the killing and explained his reasoning. In that message, Fairbanks wrote that he had acted because he did not want Condalucci to have the opportunity to harm children again, framing the killing as a preventive act rather than one carried out in response to a specific new threat he had witnessed firsthand. The email itself became a central piece of evidence in the case that followed, offering investigators a direct and detailed account of Fairbanks's state of mind in his own words, an unusual level of insight into a defendant's reasoning that is rarely available so plainly in cases of this kind. When the case went to trial, Fairbanks argued that his actions were taken in self-defense, suggesting that the confrontation at Condalucci's home had escalated in a way that left him no choice but to use lethal force in the moment. Prosecutors in Douglas County pushed back firmly against that characterization. They argued that the email Fairbanks sent afterward, along with other evidence gathered during the investigation, demonstrated that he had gone to Condalucci's home already intending to confront and ultimately shoot him, rather than finding himself in an unplanned situation that spiraled into violence. The prosecution's position was that Fairbanks's own account of his motivations, protecting children from a man he believed was likely to reoffend, undercut rather than supported a claim of spontaneous self-defense, since it pointed toward premeditation rather than a sudden and unanticipated threat. Fairbanks's defense attorney offered a more sympathetic framing of his client's actions during the proceedings, acknowledging that, in hindsight, there may have been a better course of action available to him than driving to Condalucci's house and confronting him directly. The attorney argued that the anonymous email Fairbanks sent afterward, rather than reflecting cold calculation, actually demonstrated a form of accountability, suggesting that a man attempting to evade responsibility for a premeditated killing would have been unlikely to volunteer a detailed written confession to the media of his own accord. The case took on an additional layer of complexity because of the reaction from within Condalucci's own family. Amanda Henry, his daughter and one of his victims, spoke publicly during the proceedings and expressed a view that split sharply from what might have been expected of a victim's family member. Rather than supporting a harsh sentence for the man who killed her father, she stated that she wished the sentence had been somewhat lighter than what was ultimately handed down, a striking reflection of how complicated grief and harm can become when the person killed was both a father to some and an abuser to others within the very same family. Her willingness to voice that view publicly underscored how a case like this one resists simple categorization into villain and hero, since even those closest to the man who was killed did not agree among themselves about what an appropriate consequence for his death should look like. In July of 2021, Fairbanks was sentenced to a term of 40 to 70 years in prison, a substantial sentence that placed his case closer in severity to Patrick Drum's life sentence than to the far more lenient outcomes seen in cases like Gary Plochet's probation or the eventual release granted to Ellie Nessler. The length of the sentence reflected the same underlying legal distinction seen in Drum's case. Fairbanks was not the parent of a child Condalucci had harmed, and his stated motivation, protecting hypothetical future victims rather than responding to a specific and immediate act of violence against a child of his own, did not carry the same weight in the eyes of the court as the raw, personal grief that shaped the outcomes of other cases in this list. The Fairbanks case sits at a difficult intersection of vigilante justice, self-defense claims, and a killer's own written explanation of his reasoning, all layered on top of a family that was itself divided over how to feel about the outcome. It offers a clear illustration of how the justice system tends to draw a firmer line and impose a harsher consequence when the person carrying out a killing is not the parent of the specific child who was harmed, but rather someone acting on a broader, more generalized belief that a convicted offender continues to pose a danger to children in the community at large. Whatever sympathy Fairbanks may have earned from segments of the public who agreed with his stated reasoning, the court's sentence made clear that an anonymous confession explaining a desire to protect unnamed future victims would not be treated with the same leniency the legal system has, at times, extended to a parent responding directly and immediately to harm already inflicted on their own child. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. An anonymous email to a newsroom unravels a killing that even the victim's own daughter struggled to condemn. Next, the story moves to Highland Park, Michigan, where a father's response to his son's confession would cross a line that no court could excuse. Case 9. Jamar Pinckney Sr. Highland Park is a small city surrounded on nearly all sides by Detroit, Michigan, a community that has weathered decades of economic hardship alongside its larger neighbor. It is a place where families often live close together, sometimes across multiple households, and where a private family crisis can turn, in the span of a single night, into a case that shocks even people accustomed to hearing about violence. This case does not involve a parent avenging a child against an outside abuser. It involves a father who became, in a matter of hours, both the person delivering justice and the one committing an irreversible act of violence against his own son. Jamar Pinckney Jr. was 15 years old and lived with his mother, Lizette Cherry, in Highland Park. According to Cherry's later account to reporters, her son came to her with a disclosure that no parent wants to hear. He admitted that he had engaged in what was described as inappropriate contact with his 3-year-old half-sister. Cherry, faced with this confession from her teenage son, made the decision to call the boy's father, Jamar Pinckney Sr., who was 37 at the time, and tell him what their son had admitted to doing. She later recalled telling Pinckney Sr. directly that this was not something that could simply be swept under the rug, a statement that reflected her own determination that the disclosure needed to be addressed seriously rather than quietly absorbed within the family. What Cherry did not anticipate was the form that seriousness would take once Pinckney Sr. arrived at her home. According to her account, he showed up not long after their conversation and began by pistol whipping his teenage son inside the living room where the boy lived with his mother. Cherry pleaded with Pinckney Sr. to stop, but according to her description of events, he did not relent. Instead, he forced the boy outside, marching him toward a nearby vacant lot despite his mother's continued pleas. Once at the lot, Pinckney Sr. allegedly made his son remove his clothing and kneel on the ground. What followed was not a beating meant to frighten or punish in a way that would leave the boy alive to reflect on what he had done. Pinckney Sr. shot his son once in the head, killing him at the scene. He was arrested and charged in connection with his son's death, a case that drew disturbing attention not because the underlying disclosure, a teenager's admission of inappropriate contact with a much younger sibling, was itself unheard of within families dealing with abuse, but because of the swift and lethal escalation that followed almost immediately after the confession was made. The case sits apart from nearly every other entry in this list in a critical way. In the other cases explored here, a parent's violence was directed outward, toward an adult who had allegedly harmed that parent's own child, someone the parent viewed as a predator, deserving of retribution. The legal system had either failed to deliver or was moving too slowly to provide. Here, the roles were collapsed into a single family unit in a way that defies the simpler narrative of a protective parent avenging an innocent child against an outside threat. The victim of the killing was, himself, a child. He was also, according to his mother's account, someone who had just confessed to harming an even younger child within the same family, a 3-year-old girl who was his own half-sister. This convergence, a parent responding with lethal violence to a disclosure of abuse committed not by an outsider, but by his own teenage son, raises questions that are more troubling and less easily resolved than those found elsewhere in this list. It does not fit neatly into the framework of a parent stepping in where the justice system failed to protect a child from an external threat. Instead, it reflects a father's decision to respond to a confession of wrongdoing from his own child with an act of violence so extreme that it ended that child's life entirely, foreclosing entirely any possibility of the boy facing appropriate consequences through the legal or family systems that exist, however imperfectly, to address situations exactly like this one. There is no available public record establishing what became of the case beyond Pinckney Sr.'s arrest and the news coverage that followed shortly after the killing. What is documented clearly is the sequence itself: a mother's decision to disclose her son's admission to his father, believing that doing so was the responsible course of action rather than concealing it, and a father's response that moved within a very short span of time, from confrontation to physical violence to a killing carried out in a vacant lot, stripped of any of the deliberative process that even the other, more legally lenient cases in this list at least nominally involved. This case is included here not to draw an equivalence between Jamar Pinckney Sr. and parents like Gary Plauché or Aaron Spencer, whose actions, however legally fraught, were directed at adults accused of preying on their children from outside the family. It is included because it represents the far end of a spectrum this entire list is built around, the point at which a parent's belief that they must deliver consequences themselves rather than trust institutions meant to handle disclosures of abuse curdles into something that cannot be framed as protection of any child, since the child harmed in the abuse disclosure and the child killed in response to it were, in this case, one and the same family, torn apart from multiple directions at once. It stands as a stark reminder that the impulse driving so many of the cases in this list, a parent's belief that they alone can deliver the justice a situation demands, does not always lead toward protection. Sometimes, as this case makes painfully clear, it leads somewhere far darker, with no simple resolution and no framework of forgiveness or public sympathy waiting on the other side. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. A vacant lot in Highland Park holds no easy answers, only a family fractured beyond repair. Next, the story moves to a small Texas town, where a father would face no charges at all for what he did inside a horse barn. Case 10. The Shiner. Texas Father Shiner is a small town in Lavaca County, Texas, known mostly for its brewery and its close, rural community, where families often gather for weekend cookouts on properties with horses, chickens, and wide-open land. It was during one such gathering in June of 2012 that an ordinary Saturday afternoon turned into a case that tested the limits of Texas law regarding the defense of a child. The family had gathered at their property for a social occasion, with adults tending to horses outside, while children moved freely around the home and surrounding buildings. At some point, the family's 5-year-old daughter walked toward the barn to feed the chickens, a simple chore in a setting that likely felt entirely safe to everyone present. Her father, a 23-year-old man whose name was withheld by authorities to protect his daughter's identity, was elsewhere on the property when he heard his daughter begin screaming. He ran toward the sound and entered the horse barn, where he found a man described as a casual acquaintance of the family, a 47-year-old ranch hand working as a horse groomer, in the act of sexually abusing his daughter. According to Lavaca County Sheriff Micah Harmon, the father did not hesitate. He began striking the man, and the beating continued until the man was unconscious. Witnesses who arrived at the scene shortly afterward described finding the alleged abuser already on the ground, not moving. The father immediately contacted emergency services rather than fleeing or attempting to conceal what had happened. His daughter was taken to a hospital, where she was treated for injuries described by authorities at the time as minor in a physical sense, alongside injuries of a different kind that no medical treatment could fully address. The man who had been beaten died from his injuries, with the county coroner determining the cause of death to be blunt force trauma to the head and neck. Sheriff Harmon noted that authorities had not been able to locate the deceased man's relatives, who were believed to reside in Mexico, complicating the investigation in its early stages, even as the central facts of what had occurred inside the barn remained largely undisputed. Police publicly stated that they had found no reason to disbelieve the father's account of what had happened, a notable departure from many of the other cases in this list, where investigators and prosecutors frequently contested the parents' version of events or the necessity of the force used. Legal experts who commented on the case at the time pointed to a specific and relevant principle within Texas law and broader American self-defense doctrine. In most jurisdictions, according to standard legal texts on criminal law, the use of a person's own hands and fists, absent any other weapon, in defense of oneself or another person, is generally treated as inherently reasonable force, a much lower legal bar to clear than cases involving firearms or other weapons. Because the father in this case used no weapon beyond his own hands, and because he was actively interrupting an assault in progress rather than retaliating afterward or hunting down a suspect once the immediate danger had passed, the legal analysis of his actions differed meaningfully from cases like Aaron Spencer's or David Barajas's, where the use of a firearm and questions about timing and premeditation became central to the prosecution's case. Even so, some commentators raised concerns about the case, questioning why the father had not immediately been arrested and charged with murder, given that a man had died as a result of the beating. These critics argued that regardless of the sympathetic circumstances, a legal system that allows any private citizen to determine, in the moment, that lethal force delivered by bare hands is justified against someone caught committing a crime, risks normalizing exactly the kind of vigilante justice this list is built around, an outcome they viewed as dangerous regardless of how understandable the underlying emotional response might be. A grand jury in Lavaca County was convened to review the circumstances of the killing and determine whether the father should face any charges. After reviewing the evidence, including the medical findings, witness statements, and the sequence of events as described by the father and corroborated by his daughter's injuries, the grand jury declined to indict him. The formal legal outcome of the case, then, was that no crime had been committed at all in the eyes of Texas law. The father had interrupted an active sexual assault against his young daughter and used force, without a weapon, that resulted in the death of the man responsible, and the state ultimately concluded that this response fell within the bounds of legally justified defense of another person. This case stands out among the others in this list precisely because of how cleanly it resolved within the existing legal framework, without the extended trials, contested timelines, or years of imprisonment that defined so many of the other stories here. Unlike Ellie Nessler, who fired shots into a man already restrained and shackled in a courtroom well after the abuse had ended, or Aaron Spencer, whose case remained snarled in questions about intent and premeditation, the Shiner father's actions took place in the middle of an ongoing crime, in direct physical response to what he personally witnessed happening to his daughter at that exact moment. The law has long recognized a meaningful distinction between force used to stop an assault as it happens and force used afterward, once the immediate danger has passed. And this case became one of the clearest illustrations of how that distinction can determine whether a parent walks away facing decades in prison or, as happened here, no charges whatsoever. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. A Texas grand jury finds no crime in a father's response to what he found inside a barn. Next, the story crosses an ocean to a French father who would spend 30 years and a small fortune chasing a truth two countries tried to bury. Case 11. André Bambasky Pecbusque is a small commune in southern France, not far from Toulouse, the kind of quiet residential town where an accountant could raise a family and expect nothing more dramatic from life than the usual rhythms of work and childhood. It was here, in the early 1970s, that André Bambasky lived with his wife, Danielle Gonin, and their two children, a life that seemed, on the surface, entirely unremarkable. That ordinary existence would eventually give way to one of the longest and most extraordinary pursuits of private justice in modern European history, a case that would take nearly 3 decades to resolve and would ultimately involve an abduction carried out across an international border. Bambasky's family had lived for a time in Casablanca, Morocco, where he worked as an accountant. It was there that Danielle met a German doctor named Dieter Krombach, who worked at the German consulate and had built a career as a cardiologist. Krombach's first wife had died suddenly at a young age, and not long after meeting the Bambasky family, Krombach and Danielle began a secret affair. Eventually, both left their respective spouses, and Danielle married Krombach in 1977. The two children from Bambasky's marriage, a son named Nicholas and a daughter named Kalinka, eventually went to live with their mother and her new husband in Lindau, Germany, splitting time between households in a custody arrangement that was, by most accounts, unremarkable for a family navigating divorce and remarriage. Kalinka Bambasky grew into a healthy, athletic 14-year-old, attending a French-language boarding school in Germany. In the summer of 1982, she went to stay with her mother and stepfather in Lindau for her school holiday, just as she likely had many times before. On the evening of July 9th, according to Krombach's own account, he injected Kalinka with a compound called cobalt ferlicate, an iron and cobalt preparation he told investigators he frequently gave to family members and friends. His explanation for the injection shifted over time. He first said it was meant to help her tan more easily, and later claimed it was intended to treat anemia. He also told authorities that Kalinka had complained of feeling unwell that evening, and that he had additionally given her a sleeping tablet before leaving her to rest. According to Krombach, he did not see Kalinka again until the following morning. When he went to wake her for breakfast and found her unresponsive, he called for help immediately. When Kalinka's biological father received the phone call from Danielle, informing him that their daughter was dead, André Bambasky could not process what he was hearing. She had been, by every account he knew of, a happy and healthy teenager, active in sports and full of energy. An autopsy was arranged, and in an arrangement that would later draw significant scrutiny, Krombach, himself a licensed physician, was present during the examination of his stepdaughter's body. The findings from that initial autopsy were deeply troubling. Examiners found that Kalinka had choked on her own vomit while unconscious. They also discovered tearing in her genital area, along with a whitish fluid on her legs that resembled semen, and multiple puncture marks on her arms, legs, and throat, consistent with more injections than Krombach had initially described. No toxicology testing was conducted at the time, and the official cause of death remained officially unclear, even as the physical findings pointed towards something far more troubling than a simple medical accident. Bambasky refused to accept his ex-wife's suggestion that Kalinka had simply died because it was, in her words, her time to go. He became convinced that Krombach had assaulted his daughter and then caused her death, whether intentionally or in a panicked attempt to prevent her from disclosing what had happened. He began pressuring German authorities to pursue additional investigation and testing of Kalinka's tissue samples, a campaign that would consume the coming decades of his life. A German forensic scientist eventually reviewed the timeline Krombach had provided and found it did not hold together. The undigested food found in Kalinka's stomach suggested she had died relatively soon after her evening meal, not in the early morning hours as Krombach claimed, and the presence of aspirated stomach contents in her lungs pointed to a death that occurred while she was in a coma or under some form of chemical sedation, not naturally in her sleep. The expert concluded that an injection administered shortly after dinner was the more likely cause of the sequence of events that led to her death, directly contradicting Krombach's account. Despite these findings, German prosecutors ultimately declined to bring charges against Krombach, citing the rape assessment as inconclusive without more definitive physical evidence. Bamberski, unwilling to accept this outcome, pushed for French authorities to exhume his daughter's body for an independent examination. When that exhumation took place, investigators made a discovery that shocked even those who had already suspected wrongdoing. Kalinka's genitals had been removed during the original autopsy conducted in Germany and had never been returned or accounted for, a loss that made it impossible to conduct the kind of physical evidence testing that might have definitively established whether she had been sexually assaulted before her death. Frustrated by the roadblocks he faced in Germany, and increasingly convinced that Krombach's standing in the community, including his consular connections and medical reputation, was shielding him from serious scrutiny, Bamberski turned his efforts toward France. In 1983, he distributed leaflets throughout Krombach's hometown of Lindau, publicly accusing him of raping and murdering his daughter, an act that drew attention to the case but did not immediately produce the legal outcome Bamberski was seeking. Because German authorities had already closed their investigation and refused France's requests to extradite Krombach for trial, French courts eventually proceeded to try him in absentia. In 1995, more than a decade after Kalinka's death, a French court convicted Krombach of involuntary manslaughter without him ever appearing before the court in person. That conviction was later overturned by the European Court of Human Rights on procedural grounds, since trying a defendant in absentia without adequate legal representation raised serious due process concerns under European law. The overturned verdict left Bamberski, once again, without any binding legal consequence for the man he believed had killed his daughter. For years, Bamberski continued pressing German authorities to extradite Krombach to France so that a proper trial, with the defendant present, could finally take place. In 2004, a German court flatly declined France's extradition request, ruling that the matter was closed as far as German law was concerned. By this point, more than 2 decades had passed since Kalinka's death, and Bamberski was growing increasingly aware that the statute of limitations on pursuing the case in France was set to expire in 2012, a deadline that would permanently foreclose any possibility of Krombach ever facing justice through conventional legal channels. Faced with what he saw as a closing window and a German legal system that had repeatedly protected Krombach, Bamberski made the decision that would define the final and most controversial chapter of his 3-decade pursuit. He paid several men to abduct Krombach from his home in Bavaria and deliver him across the border into France. On October 17, 2009, Krombach, by then 74 years old, was beaten by 3 men at his home in the town of Scheidegg and driven across the border to Mulhouse, France, where he was left chained to a fence near the local police station, suffering from a fractured skull sustained during the abduction. Bamberski was arrested shortly afterward, found in possession of 19,000 euros, the amount he had intended to pay the men who carried out the operation. He was released on bail while the legal fallout from the abduction unfolded. Germany immediately demanded that Krombach be returned and that Bamberski and the men involved in the kidnapping be extradited to face charges there. France refused these demands, instead moving forward with its own legal proceedings against Krombach for Kalinka's death, keeping him in custody in France ahead of a new trial scheduled for 2011. As the case developed, additional troubling information surfaced about Krombach's past. Testimony emerged from a German woman who said she had had an affair with Krombach when she was only 16 years old, and who described how he would drug his wife in order to facilitate these encounters. Testimony that painted a broader and deeply disturbing pattern of behavior, extending well beyond the specific circumstances of Kalinka's death. Krombach's legal team made 7 separate attempts to have the new trial halted, all of which failed. When the trial finally proceeded in 2011, nearly 30 years after Kalinka's death, it was described by observers as the culmination of decades of what one report called exhausting initiatives, dysfunction, and judicial bungling across 2 countries. The court found Krombach guilty of causing intentional bodily harm resulting in unintentional death and sentenced him to 15 years in prison. Krombach's conviction was appealed all the way to the European Court of Human Rights, which upheld the verdict in 2018, finally closing the legal chapter of Kalinka's case for good, decades after her death and years after the abduction that had forced the matter back into a courtroom in the first place. Bamberski himself still had to answer for his role in the kidnapping. Germany's demand that he be extradited to face charges there for orchestrating the abduction was rejected by a French court in Toulouse, which ruled that Bamberski would instead be tried within France. That trial took place in 2014, more than 3 decades after Kalinka's death, and Bamberski confessed openly to arranging Krombach's abduction, telling the court that he had felt morally bound to do it. He received a 1-year suspended sentence for his role in the kidnapping. The prosecutor overseeing the case publicly praised Bamberski for what was described as his courage and perseverance throughout the decades-long pursuit of justice for his daughter, a striking statement from within a legal system Bamberski had, by his own admission, circumvented through an act of kidnapping in order to finally see justice delivered. Speaking after Krombach's conviction was finalized, Bamberski reflected on what the outcome meant to him, saying that his first thought was always for Kalinka, and that what he had wanted all along was simply a complete and fair trial for the man who had taken her life. He said that goal had finally been achieved, and that with justice done in her memory, he could finally begin to properly mourn his daughter, something the unresolved uncertainty of the previous decades had never fully allowed him to do. The case became the subject of multiple documentaries and dramatized films in the years that followed, drawn to the singular nature of a father's decades-long refusal to accept a system's failure, a refusal that ultimately led him not to a single act of impulsive violence, as in so many of the other cases in this list, but to a calculated, expensive, and years-long campaign that crossed international borders and reshaped the legal relationship between 2 European nations in the process. Unlike Ellie Nessler's courtroom shooting or Gary Plochet's single gunshot in an airport terminal, Bamberski never took a life himself. His pursuit stands as a different kind of vigilante justice entirely, one built not on a single moment of violence but on decades of unrelenting persistence, culminating in an abduction that, however illegal, finally forced a reluctant justice system to deliver the trial he had spent nearly 30 years demanding. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. 30 years of persistence finally force a courtroom to open in France, closing a case 2 nations had tried to let go. Next, the story moves to San Francisco, where 2 parents would follow their daughter into a car outside a football stadium and never look back. Case 12. Barry Gilton and Lupe Mercado. San Francisco's Bayview Hunters Point neighborhood sits along the southeastern edge of the city, an area that has long dealt with higher rates of violence and fewer resources than much of the rest of San Francisco, even as the city around it has grown into one of the wealthiest in the country. It was in this community, in 2012, that 2 parents faced a situation that many families confront in some form: a teenage daughter drawn into a relationship with an older man that the parents recognized, correctly, as dangerous, but that the systems meant to intervene seemed unable or unwilling to stop in time. Barry Laprelle Gilton had worked as a coach with the Boys and Girls Club in San Francisco, a role that placed him, for years, in a position of mentorship and guidance for young people in his community. Lupe Mercado was the mother of Gilton's daughter, a 17-year-old girl who, in early 2012, had become involved with a 22-year-old man named Calvin Sneed. From the perspective of both parents, the relationship carried immediate warning signs. Sneed was significantly older than their daughter, and both parents grew increasingly convinced that his interest in the teenager was not romantic in any conventional sense but predatory, oriented toward exploitation rather than genuine connection. According to accounts of the case, Gilton and Mercado witnessed Sneed take their daughter on at least one occasion in a manner that alarmed them further, and they came to believe, based on what they observed and learned, that Sneed's intentions toward the girl involved selling her, a fear rooted in the broader and well-documented pattern of older men targeting vulnerable teenage girls for commercial sexual exploitation. This was not a suspicion the parents kept to themselves or attempted to handle entirely on their own from the outset. Reports on the case indicate that both Gilton and Mercado made efforts to seek help through official channels, reaching out to both law enforcement and child protective services in an attempt to intervene in the relationship and separate their daughter from Sneed before the situation escalated further. Whatever response the parents received from those institutions, it did not resolve the situation to their satisfaction, and the relationship between their daughter and Sneed continued. The specific details of what interactions took place between the family and various agencies in the weeks leading up to what followed are not fully documented in public reporting, but the outcome makes clear that whatever intervention occurred, it did not remove Sneed from their daughter's life or address the parents' fears about his intentions toward her. On June 4, 2012, the situation reached its breaking point. Gilton, the former Boys and Girls Club coach who had spent years working to guide young people in his community, shot and killed Calvin Sneed while Sneed was in his car outside Candlestick Park, the longtime home of the San Francisco 49ers football team, before its closure and demolition in the years that followed. The shooting took place in a public area, and the killing was quickly connected to the ongoing tension between Sneed and the family of the teenage girl he had been involved with. Law enforcement's response to the case extended well beyond simply charging Gilton with the killing itself. Prosecutors ultimately brought charges against a total of 4 people in connection with Sneed's death, including both Gilton and Mercado, the girl's mother, as well as 2 additional individuals who were alleged to have been involved in the events surrounding the shooting. This wider scope of charges set the case apart from many of the other entries in this list, most of which involve a single parent acting alone in a moment of confrontation or premeditated violence. Here, the case authorities built suggested a coordinated effort involving multiple people connected to the family, all drawn together by a shared concern for the same teenage girl and, according to prosecutors, a shared willingness to see that concern through to a lethal conclusion. The case drew significant local media attention in San Francisco, in part because of Gilton's public role prior to the shooting. His work with the Boys and Girls Club had positioned him, for years, as someone entrusted with the well-being and mentorship of young people in his community, a role that stood in stark and uncomfortable contrast to the charges he now faced for his involvement in a killing connected to concerns about his own daughter's safety. For some observers, this contrast underscored the depth of desperation the parents must have felt. A man who had spent his career working within the system to help other people's children, ultimately concluding that the same system could not adequately protect his own daughter from a man he and her mother believed intended to exploit her. Beyond the basic facts of the shooting and the resulting indictments, detailed public information about the trial, its arguments, and its ultimate resolution remains limited. What is documented clearly is the sequence that led to it: a teenage girl's involvement with a significantly older man, a set of parents who grew convinced that man intended to sell their daughter, documented attempts by those parents to seek help through police and child protective services, and finally, when those efforts did not resolve the danger they perceived, a killing carried out in a public parking area outside a football stadium that had, for decades, been one of the city's most recognizable landmarks. This case occupies a distinct place among the others explored in this list because it involves 2 parents acting together, rather than a single mother or father carrying the full weight of the decision alone, and because it involves additional individuals beyond the immediate family who were also charged in connection with the killing, suggesting a broader coordinated response rather than a single spontaneous act of rage or grief. It also stands apart in the specific nature of the threat involved. Unlike cases centered on abuse that had already occurred, where a parent's violence followed a disclosure of harm already inflicted on their child, this case centers on parents who believed they were acting to prevent an anticipated future harm, the exploitation and sale of their daughter, based on their own observations of Sneed's behavior and intentions rather than a completed act that had already caused injury. That distinction places the Gilton and Mercado case in an unusual middle ground within the broader pattern this list has traced. It shares with cases like James Fairbanks's the element of preventing an anticipated future harm rather than responding to a completed one, yet it differs sharply in its immediate, deeply personal connection to the parent's own child, a feature that aligns it more closely with cases like Gary Plauchet's or Aaron Spencer's, where a parent's actions were inseparable from a specific, direct threat to their own son or daughter. The involvement of both parents together, along with 2 additional people drawn into the case, also raises questions this list has not encountered elsewhere about how a family's shared fear for a child can translate into a coordinated decision to act outside the law, rather than the more commonly seen pattern of a single parent acting alone in an isolated moment of crisis. What remains constant across this case and so many others explored throughout this list is the underlying pattern. Parents who believed, rightly or wrongly, that the institutions meant to protect their children, whether police, courts, or child protective services, had failed to respond adequately to a threat they could see clearly in front of them, and who ultimately decided that the only remaining option was to remove that threat themselves. Whether that belief was accurate in every detail of what Sneed intended for their daughter, the documented efforts by Gilton and Mercado to seek help through proper channels before the shooting suggest a family that did not turn to violence as a first resort, but rather as what they came to see, after other avenues failed to produce the outcome they needed, as the only path left available to protect their daughter from a danger they were convinced was both real and imminent. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Outside a stadium built for a different kind of Sunday, 2 parents' fear for their daughter ends in gunfire and 4 arrests. Next, the story crosses into rural India, where a father would strike a private bargain with his infant daughter's attacker on the back of a motorcycle. Case 13. Paramjit Singh Kotli Ablu is a small village in Punjab, India, part of a region built around agricultural life, tightly knit communities, and family structures where the reputation of a household carries weight across generations. It is a place where news of a crime against a child spreads quickly through informal networks of relatives and neighbors, often faster than it moves through official channels, and where a family's response to tragedy can become the subject of conversation for years afterward. In April of 2014, one father's response to an unspeakable crime against his infant daughter became a case that drew national attention across India and raised difficult questions about the limits of a justice system many rural families view as slow, distant, and unreliable. Paramjit Singh lived in Kotli Ablu with his family, including a 7-month-old daughter, an age at which a child depends entirely on the adults around her for safety, unable to communicate what has happened to her in any way beyond visible signs of distress or injury. According to reports on the case, Paramjit discovered that his infant daughter had been sexually assaulted by a 17-year-old local teenager named Parminder Singh, who had no prior familial connection to the family. The exact circumstances under which Paramjit made this discovery are not detailed extensively in available reporting, but what followed moved quickly through the formal channels of the Indian legal system, at least initially. Authorities arrested Parminder Singh in connection with the assault, and the case proceeded toward trial through the courts, the ordinary and expected path for a criminal matter of this severity. It was during the trial process itself that the case took its unusual and violent turn. According to accounts of what happened, Paramjit approached Parminder privately at some point during the proceedings and proposed what has been described as a deal between the two of them, an arrangement made outside the formal channels of the court and without the knowledge of the authorities overseeing the case. What exactly Paramjit told the teenager to secure his cooperation, or what Parminder believed he was agreeing to, remains unclear from available reporting, but the arrangement culminated in Parminder voluntarily leaving the courthouse with Paramjit, the two of them departing together on the back of Paramjit's motorcycle. What followed was carried out with a level of premeditation and control that distinguishes this case from many of the more impulsive, in-the-moment killings and acts of violence documented elsewhere in this list. Rather than confronting Parminder in a sudden burst of rage, Paramjit had, according to reports, drugged a Coca-Cola that he gave to the teenager incapacitating him to some degree before the two ever left the courthouse together. He then transported Parminder to the nearby village of Jumba, a location apparently chosen deliberately, away from the courthouse and any immediate witnesses who might intervene or later corroborate the exact sequence of events. Once in Jumba, Paramjit tied Parminder to a tree. What followed was not a quick or contained act of violence, but an extended assault. Paramjit beat the teenager severely, and in an act that set this case apart even from other instances of parents inflicting serious violence in response to the abuse of their children, he then severed the young man's hands. The specific method used to carry out this act, and the full medical outcome for Parminder in its aftermath, are not detailed extensively in the reporting available on the case, though the severity of the injury alone marks this as one of the most extreme acts of retaliatory violence documented in this list. Word of what had happened spread quickly, and authorities soon connected Paramjit to the disappearance of Parminder from the courthouse and the violence that followed. Paramjit was arrested and charged in connection with the attack, with reports indicating that he faced a charge of attempted murder given the severity of the injuries inflicted, since Parminder survived the assault despite the extreme violence he suffered. This distinguishes Paramjit's case from many others in this list, where the person targeted for retaliation did not survive the parents' response. Here, the legal proceedings that followed centered not on a killing, but on an extraordinarily severe act of premeditated bodily harm carried out against a person who was, at the time, formally still presumed innocent in the eyes of the law, since the original trial against him had not yet reached a verdict when Paramjit intervened. This detail matters significantly in how the case has been discussed and understood in the years since. Unlike cases such as Ellie Nessler's or Marianne Bachmeier's, where the parents' violent act followed either a conviction or an overwhelming body of evidence and, in some instances, a confession from the accused, Paramjit's actions took place while Parminder's guilt had not yet been formally established through a completed trial. The case raises a distinct and uncomfortable question that runs through several entries in this list, but appears here in particularly sharp relief. What happens when a parent, convinced of an accused person's guilt based on their own knowledge and belief, decides not to wait for the legal process to reach its conclusion before delivering what they see as an appropriate consequence? The severity and specific nature of the injury Paramjit inflicted, the deliberate severing of Parminder's hands rather than a more conventional beating or use of a weapon resulting in death, also sets this case apart in another way. Reports on similar cases from the region have noted that this type of injury carries a particular symbolic weight within some communities, understood by those who carry it out as a punishment meant to permanently and visibly mark the person responsible for a crime, ensuring that the consequence of their actions remains evident to everyone who encounters them for the rest of their life, rather than existing only as a private matter, resolved through imprisonment and eventually forgotten by the wider community. Whether this framing accurately reflects Paramjit's own reasoning in this specific case is not something that can be confirmed from the available public record, but the pattern itself has been documented in other cases within the region involving similar acts of retaliatory violence tied to crimes against children. The case generated significant attention within Indian media at the time, feeding into broader and ongoing national conversations about the pace and reliability of the country's justice system in cases involving sexual violence against children, conversations that had already been intensified by several other high-profile cases in the years surrounding this one. For many observers, Paramjit's actions, however extreme, were understood within the context of a justice system that many families in rural India view as slow, difficult to navigate, and prone to producing outcomes that fail to match the severity of the crimes being prosecuted, particularly in cases involving very young victims who cannot testify in the same way older survivors might be able to. At the same time, the case drew clear condemnation from legal officials and commentators who argued that regardless of how justified a parent's anger and fear might feel in a moment like this, allowing private individuals to decide guilt and administer punishment outside the courts represented a serious threat to the rule of law, one that could just as easily be misapplied against an innocent person as it might, in this case, have been directed at someone whose guilt seemed clear to the family involved. The fact that Parminder had not yet been convicted at the time Paramjit acted against him became a central point of concern for those raising this argument, since the entire premise of a trial is to establish guilt or innocence through a process designed to weigh evidence carefully, a process that Paramjit's intervention effectively bypassed entirely. Paramjit Singh's case remains, within the scope of this list, one of the clearest examples of a parent taking matters into their own hands, not after a legal process had concluded and left them dissatisfied with the result, but during the process itself, before any formal determination of guilt had been reached. It stands as a stark illustration of how deeply a parent's certainty about what happened to their child, particularly a child too young to speak for herself, can override even the basic procedural safeguards that a justice system is built around, regardless of what the ultimate outcome of a completed trial might eventually have been. Whatever legal consequences followed for Paramjit himself, the case left behind an infant victim who would grow up without any memory of what had happened to her. A teenager, permanently marked by an act of retaliation carried out before his own guilt had ever been formally proven, and a village where the story of what happened on the back of that motorcycle would likely be told and retold for years to come. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. A motorcycle ride from a Punjab courthouse ends in a punishment carried out before any verdict was ever reached. Next, the story moves to New Delhi, where a father's dinner invitation would mask an entirely different kind of reckoning. Case 14. Vinod Kumar. New Delhi is one of the largest and most densely populated cities in the world, a sprawling capital where ancient neighborhoods sit alongside modern high-rises, and where the sheer scale of the city can make individual tragedies feel, at times, invisible within the broader flow of daily life. In November of 2014, one such tragedy became impossible to overlook when a father's private response to his daughter's assault came to light through his own decision to walk into a police station and confess exactly what he had done. Vinod Kumar was 36 years old, married, and the father of 4 daughters and 2 sons, a large family living in a New Delhi neighborhood where, according to later reporting, a 45-year-old medical supplier lived nearby. According to Kumar's own account to police, this man had raped his 14-year-old daughter approximately 2 months before the events that would ultimately bring the case to public attention. Kumar told investigators that he had chosen not to report the assault to police at the time it occurred, explaining that he feared doing so would bring dishonor to his family, a concern rooted in social and cultural pressures around sexual violence that remain a significant barrier to reporting in many communities, not only in India, but in many parts of the world. For 2 months then, Kumar carried the knowledge of what had happened to his daughter without involving the authorities, a private burden that, according to his later statements to police, weighed on him even as he outwardly maintained normal relations with the man he believed responsible for the assault. Rather than confronting the man directly, or reporting him to police once his anger and grief had settled into a plan, Kumar instead extended what appeared, from the outside, to be an ordinary gesture of neighborly hospitality. He invited the man to his home for dinner. According to the account Deputy Police Commissioner R.A. Sanjeev later provided to reporters, Kumar served the man food and soft drinks that had been laced with drugs during the visit, incapacitating him over the course of the evening without his awareness of what was happening. Once the man was sufficiently subdued, Kumar gagged him using a bedsheet, and what followed was an extended period of torture rather than a quick act of violence. Kumar told police that he burned the man's genitals using hot tongs before finally strangling him to death, according to the account provided by investigators. The killing, planned carefully enough to unfold over the course of an evening under the guise of a shared meal, stands among the most methodically premeditated acts of retaliatory violence documented anywhere in this list, closer in its calculated planning to Paramjit Singh's case in Punjab than to the sudden, impulsive violence seen in cases like Ellie Nessler's courtroom shooting or the Shiner, Texas father's response to an assault he witnessed in progress. The day after the killing, Kumar made the decision to turn himself in to police, walking into a station in New Delhi and providing investigators with a full account of what he had done and why. This voluntary confession meant that, unlike many of the cases explored throughout this list, there was no extended manhunt, no contested timeline of events, and no dispute over who was responsible for the killing. Kumar's own detailed statement to police became the primary source of information about the case, an unusually direct and complete account from the person responsible, offered without the mitigating framing that defense attorneys often provide once a case reaches trial. Following his confession, Kumar was formally charged with murder and placed in jail to await trial, a process that, according to the available reporting on the case, had not yet reached its formal charge sheet stage at the time the story drew widespread attention. Under standard procedure, police were required to compile and file a detailed charge sheet with supporting evidence before the matter could proceed further through the courts, a step that had not yet occurred in the initial period following Kumar's arrest, since confessions made directly to police are generally not admissible as evidence in Indian courts without the additional supporting documentation and evidence collected through the formal investigative process. At the time, reporters attempted to reach Kumar or a legal representative acting on his behalf for comment. Neither was available, leaving his own perspective on the case, beyond the initial statement he provided to police, largely unrecorded in the public record. Similarly, limited information became available about the family of the man Kumar killed, beyond the basic fact that he left behind a wife and 2 adult children, 1 son and 1 married daughter, a family that, whatever their private feelings about the accusations against him, was left to process the sudden and violent loss of a father and husband under circumstances that placed them, however unwillingly, at the center of a case that generated significant public attention across the country. Kumar's case emerged during a period when India was already engaged in intense public discussion about how the country's legal system handled cases of sexual violence against children, discussions that had been building in the years following several other high-profile cases that drew both domestic and international scrutiny to gaps in how such crimes were reported, investigated, and prosecuted. Kumar's explanation for his initial silence, a fear that reporting the assault would bring dishonor to his family, reflected a pattern that child protection advocates and legal reform groups in India had long identified as a significant barrier preventing many families from coming forward when children, particularly daughters, experienced sexual violence. That same cultural pressure, according to some analysts who discussed cases like this one, can create a difficult and sometimes contradictory dynamic, in which a family may feel unable to pursue justice through public, formal channels, precisely because doing so risks the very reputational harm they fear, while at the same time feeling compelled toward private, violent retribution as an alternative outlet for grief and anger that cannot otherwise be safely expressed or resolved. The methodical nature of Kumar's actions, extending an invitation to share a meal, drugging his intended target gradually over the course of an evening, and carrying out an extended period of torture before finally ending the man's life, distinguishes this case from the more spontaneous acts of violence that characterize many of the other entries in this list. It suggests a period of private deliberation stretching across the 2 months between the assault on his daughter and the night of the killing, time during which Kumar apparently moved from a position of feeling unable to report the crime publicly toward a fully formed plan for how he intended to address it privately instead. Vinod Kumar's case remains, at the time of this account, an unresolved legal matter, with no publicly available information indicating the final outcome of his trial, or the sentence, if any, that was ultimately handed down. What the case does illustrate clearly, alongside so many others explored in this list, is the way cultural pressures around honor and reputation can shape not only whether a family chooses to report a crime against their child, but also the form that a parent's eventual response takes when they conclude that silence is no longer sustainable and that the formal justice system, whether out of fear, distrust, or simple unwillingness to expose their family to further scrutiny, is not a path they are willing or able to pursue. Kumar's decision to turn himself in afterward, offering a complete account of what he had done without apparent hesitation, suggests a man who, having finally acted on the private plan he had carried for months, felt no further need to conceal what he had done, even knowing it would mean facing a murder charge and the formal judgment of the very legal system he had chosen to circumvent, in delivering what he saw as an appropriate response to his daughter's assault. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. A New Delhi confession lays bare 2 months of silence and a single night of calculated reckoning. Next, and finally, the story moves to a small trailer in Indiana, where a mother's suspicion about her toddler would end with a box cutter and a fight she never planned for. Case 15. Bonita Lynn Vela. Franklin, Indiana, is a small city south of Indianapolis, a community of modest homes and trailer parks, where families often live close to extended relatives, and where the boundaries between one household's business and another's tend to blur in the tight quarters of small-town life. It was in a trailer in this community, in the final days of December 2013, that a mother's suspicion about her 2-year-old son led to a violent confrontation that would end with serious injury to a young man and criminal charges for the mother who caused it. Bonita Lynn Vela was 35 years old at the time, living in a trailer in Franklin with her family, including her toddler son and a teenage daughter who was, at the time, in a relationship with an 18-year-old young man. According to the account that emerged through police reports and subsequent news coverage, Vela had grown suspicious that her daughter's boyfriend had molested her 2-year-old son, a fear that, for any parent, would represent one of the most frightening and disorienting suspicions imaginable, particularly given the toddler's inability to communicate clearly about what, if anything, had happened to him. Rather than reporting her suspicion to police, or seeking a forensic evaluation for her son through appropriate medical or investigative channels, Vela made a decision that set the events of that December night in motion. According to reports on the case, she had been smoking marijuana that evening, and at some point she instructed her daughter to invite her boyfriend over to the family's trailer, setting up a confrontation under the pretense of an ordinary visit. The young man arrived at the trailer at around 3 o'clock in the morning, unaware of what awaited him, or that he was walking into a planned confrontation rather than the kind of casual late-night visit that had likely brought him to the home before. Once he arrived, Vela, with the assistance of 2 other individuals whose identities were not disclosed in available reporting, held the young man against his will inside the trailer for what news accounts describe as several hours. During this extended period, Vela confronted him directly about the suspected abuse of her son, demanding that he account for what she believed he had done to the toddler. The young man, according to reports on the case, denied the accusation firmly and repeatedly throughout the encounter, maintaining that he had not molested the boy at any point. The confrontation, rather than resolving through conversation or de-escalating over the hours that the young man was held in the trailer, eventually turned physical. At some point during the encounter, a struggle broke out over a box cutter that was present in the trailer, a common enough household tool that had, in the context of that night, become a weapon at the center of an escalating conflict. During this struggle, Vela cut the young man's penis with the box cutter, an injury of significant severity that required medical attention once the confrontation finally ended and authorities became involved. Reports on the incident describe the injury as occurring in the course of the struggle over the weapon itself, rather than as a single, isolated and clearly premeditated act carried out from the outset of the encounter, a detail that would later become relevant to how the case was charged and ultimately resolved through the legal system. Once the young man was able to leave the trailer, or once the situation came to the attention of authorities through some other means not fully detailed in available reporting, police were called to investigate. Officers arriving at the scene were faced with a case that combined several serious and legally complicated elements: an unconfirmed allegation of child molestation involving a 2-year-old who could not testify to what, if anything, had happened to him, a prolonged period during which an adult had been held against his will inside a private residence, and a severe physical injury inflicted with a weapon during the course of that confrontation, an injury that, whatever the underlying context, constituted a serious criminal act in its own right under Indiana law. Vela was arrested and charged in connection with the incident. Media coverage of the case at the time tended to focus heavily on the more sensational aspects of what had occurred, with headlines emphasizing the marijuana use and the specific nature of the injury inflicted, framing that, while accurate to the facts of the case, arguably obscured the more complicated underlying situation. A mother who believed, rightly or wrongly, that her young son had been sexually abused by a much older boyfriend of her teenage daughter, and who had chosen to address that suspicion through an extended, unauthorized confrontation, rather than through the channels of law enforcement, medical evaluation, or child protective services that exist specifically to investigate exactly this kind of allegation. The case proceeded through the Indiana court system, with Vela facing charges connected to both the unlawful detention of the young man and the injury inflicted upon him during the encounter. Unlike several of the more severe cases explored elsewhere in this list, where parents faced murder or manslaughter charges carrying the possibility of decades in prison, Vela's case did not involve a fatality, a distinction that shaped both the charges she faced and the eventual resolution of her case through the courts. She ultimately pleaded guilty to the charges brought against her in connection with the incident. At her sentencing, the court handed down a punishment considerably more lenient than the outcomes seen in many of the other cases explored throughout this list. Vela received 10 months of house arrest, along with an additional 6 months of probation, a sentence that allowed her to avoid any significant period of incarceration despite the severity of the physical injury she had inflicted during the confrontation. The relatively light sentence reflected several factors that distinguished this case from others involving more severe outcomes, including the fact that the young man survived his injuries, that the case involved a struggle over a weapon rather than a premeditated attack with a firearm or an extended, deliberate act of torture, and that the underlying allegation, however unproven through any formal investigation, involved the suspected abuse of a very young and particularly vulnerable child. The case never resulted in any formal determination, through a criminal trial or a Child Protective Services investigation, of whether the young man had in fact molested Vela's 2-year-old son. This lack of resolution on the underlying question that had prompted Vela's actions in the first place sets this case apart from many others in this list, where the accused party had already confessed, been convicted, or had substantial evidence of guilt established through some other process before the parent in question took violent action. Here, the entire encounter rested on Vela's own suspicion, a suspicion that, however sincerely held, was never tested or confirmed through the kind of forensic or investigative process that exists specifically to establish the truth in exactly these situations, particularly when the alleged victim is a toddler too young to describe what happened to him in his own words. This uncertainty at the center of the case raises questions that echo throughout several entries in this list, but appear here with particular sharpness. Vela's decision to summon the young man to her home under false pretenses, hold him for hours, and ultimately injure him severely, was undertaken without any confirmation, medical or otherwise, that abuse had actually occurred. Had her suspicion proven unfounded, the case would represent an especially troubling example of a parent inflicting serious, permanent harm on an innocent person based entirely on an unverified fear. Had her suspicion been accurate, the case would instead sit alongside others in this list where a parent's belief that formal channels would move too slowly or fail to adequately protect their child led them toward a private and violent resolution instead. Because the underlying question was never formally resolved through the legal system, this case occupies a uniquely uncertain place among the 15 stories explored here, one where even the most basic starting premise, whether a crime against a child had actually occurred at all, remains, to this day, an open question rather than an established fact. What can be said with certainty is that a 2-year-old boy in Franklin, Indiana, became, in the final days of 2013, the center of a violent confrontation between the adults in his life, one that resulted in serious injury to a young man, criminal charges, and a period of house arrest for his mother, and no clear public resolution of the fear that had set the entire sequence of events into motion in the first place. Whatever happened or did not happen to that toddler in the months before that December night, the case stands as a stark illustration of how a parent's suspicion alone, absent confirmation through the systems specifically designed to investigate such claims, can nonetheless escalate into serious, life-altering violence, carried out not in a moment of sudden, uncontrollable rage upon witnessing harm firsthand, as in the Shiner, Texas case, but through a planned and extended confrontation that unfolded over hours inside a family's own home. If you enjoyed this breakdown, make sure to subscribe. Thanks for watching, and I'll see you in the next one.